Good morning or good afternoon, everyone. Thank you for joining us for today's session, Roadways to Justice, Reforming the Criminal Justice System, with our distinguished speaker, Roc Clark. Before we begin, just a couple of quick housekeeping announcements. The first announcement, you may have noticed that you're in listen-only mode. This is to cut down on the amount of background noise so everyone can hear our great speaker. However, questions are welcome during today's presentation. To ask questions on your screen, you should still have the GoToWebinar pop-up. Use that pop-up and click on questions to ask questions during the session, and we'll try our best to weave them into the presentation. Our second announcement, today's session is not for CLE credit. However, FastCase does offer CLE webinars. Those are on Thursday afternoons at 1 p.m. Eastern Time, and you can sign up for those by going to fastcase.com/webinars. All right, with that, I'm going to introduce our distinguished speaker. Mr. Clark, or Roc Clark, is a nationally known lecturer and author. He has written so many books that we'd be here for a good 10 minutes by the time I finished listing them, but he has done so much work in the field of professional responsibility, legal history, and other fantastic subjects. He is also a distinguished speaker, having lectured for many, many Bar Association's courses, the Department of Justice, the Department of State, a wider range of audiences, and a wide array of attendees. Literally, I have an entire page worth of material that I could tell you about Mr. Clark, but I'll let the man speak for himself. Mr. Clark, I'm going to turn it over to you.
Thank you very much, Erin, and also thank you, Morgan. As they indicated, the book is about reforming the criminal justice system, and it has an emphasis on the prosecutor playing an important role in that process. During our time together, what I hope we can do is spend time focusing on 5 different subjects. There are many more in the book, but we're going to focus on 5 during this time. One is police-involved deaths. Second is the role and history of the American prosecutor. Third, the Brady Rule. 4, wrongful convictions. And then number 5, prosecutor education. One of the great problems facing the criminal justice system is how to handle police-involved shootings of minorities, blacks, or other minorities. This is proven to be one of the most difficult areas to fix in terms of the criminal justice system. So I'd like to take you back a little bit of history because there is value in history. I first really saw how the criminal justice system handled police-involved deaths in 1970 when I entered this courtroom. This is the presiding department of the King County Courthouse in Seattle, Washington. They're all there for what is called, and some of you know this, an inquest, which is an inquiry into the death of a person killed by a police officer. The gentleman seated here is Lem Howell. He represented the family of Larry Ward, who was the Vietnam veteran who was shot by a Seattle police officer. He has been in practice in Seattle and represented families for years. The police officer can be represented. The prosecutor's job at an inquest is to neutrally present the facts. You're not supposed to take a position, but just neutrally present the facts. It's not a trial. I mean, they're not going to come back with a verdict of guilty, but what they will do is come back and answer some very specific questions about whether there was any criminality involved. So the inquest went on, and 3 out of the 5 jurors concluded that the death of Larry Ward was as a result of criminal means. All right, after that decision is made, the next question, or the next thing to be done, is for the prosecutor to decide, are we going to file criminal charges or not? And this process has worked since 1970 up through today. So the case then goes to the prosecutor. Remember that the jury concluded that the death was as a result of criminal means. The King County prosecutor, in the face of that, decided, I'm not going to file charges. Essentially said it was a split decision, and therefore he wouldn't file charges against the police officer, Hannah, who had shot Larry Ward. There was a protest, of course, afterwards. Some were arrested. And then after that, there were minor, very minor changes in the way in which inquests were handled. So we're going back 4 decades. Or over that. Let's jump forward to more recent time, to Ferguson, Missouri. And you'll recall this case. It involved Michael Brown, who was killed by a police officer. And there was protests in the streets, and this led to national news and really energized the Black Lives Matter movement. Were charges filed? No, no charges were filed. It was essentially the grand jury. The prosecutor turned it over to the grand jury to determine. They decided no charges. Just last year, the prosecutor in Ferguson re-reviewed the facts and decided, even after all that time, and by the way, incidentally, he's a black man, he decided no charges should be filed. Well, in 2015, charges were filed. This is Baltimore, in the death of Freddie Gray while he was in police custody. So charges were filed, and the prosecutor took the cases to trial. But what happened? The officer was acquitted. And here's the prosecutor, Marilyn Mosby, achieved 2 trials, no convictions, put the prosecutor in a bind. Listen to this. Her critics, many of them white, said the acquittal on Monday, coming on the heels of a hung jury in the case of Officer Williams, William G. Porter last year, is proof that she had no business bringing charges in the first place. So we have the first one in Seattle 4 decades back, no charges filed. Charges not filed in Ferguson, Missouri. Charges here filed, but then acquittals. And then to add insult to injury, she then got sued by the police officer for defamation. That case eventually was dismissed because she had immunity, but that's adding insult to injury for sure. Now, let's go back to Seattle. You see in the upper right here, that's Officer Burke, a Seattle police officer, hadn't been on the force for too long. He shot John T. Williams, the fellow down on the lower left. And let's look at the facts of the case for just a moment. Burke, 27, had been in the department for about 2 years when he stopped his patrol car in Bourne Avenue and Howell Street after watching Williams cross the street holding a knife with a 3-inch blade and a piece of wood. Williams, 50, a wood carver, was well-known chronic inebriate who had regular encounters with Seattle police. Burke got out of his car, followed Williams onto the sidewalk, shouted at him to get his attention, ordered him 3 times to drop the knife, and then he fired 5 shots when Williams didn't respond, hitting him 4 times. So there was an inquest in the King County Courthouse into, again, the criminality. Was there criminal fault? Again, this was not a trial, but they were trying to determine what happened and was there criminality involved. And this is, the questions were asked. There was a number of questions asked, but the key ones are these. And here are not only the questions, but the answer. Did Officer Burke believe that John T. Williams posed an imminent threat of serious physical harm to Officer Burke at the time Officer Burke fired his weapon? Yes, said 4 of the jurors. No, 0. And there were 4 people who didn't have a conclusion at all. But here's a key one. Based on the information available at the time Officer Burke fired his weapon, did John T. Williams pose an imminent threat of serious physical harm to Officer Burke? 1 said yes, 4 said no, 3 said unknown. All right, so those are the findings by the inquest. It then goes from, as I mentioned before, after that's the decisions have been made there and the answers have been given to the interrogatories, the prosecutor has this sort of input to determine whether or not charges should be filed. No charges were filed. This is the King County prosecutor, Dan Satterberg, and he's explaining why no charges could be filed. And as he's pointing out here he has the law with regards to justification by a police officer. It requires a jury to find that there was malice, that the officer essentially was maliciously killing Williams, that he had an evil intent when he did it. And as Satterberg explained, there's no way that a jury could conclude that. There was no evidence indicating that he acted with malice. Well, what can you do if there's a malice requirement? And remember what the inquest jury came back with. You know, was he actually in fear at the time, a reasonable fear? So here you have a requirement of malice. Was the officer being malice? No. But can you change the law so it doesn't require malice? And that's exactly what Dan Satterberg did. He sought the reform of the law. And in fact, they have now, the legislature and the governor have signed a piece of legislation that took the word malice out of the law. And since that case, another officer has been charged with murdering an individual, and that case is going to come to trial. At least it's set for trial. So what do we have? We have a vicious cycle, basically. There's a protest, there's a protest asking that charges be filed. If charges are filed, then it's usually the officer gets acquitted or there's a hung jury. If charges aren't filed, then there's a protest for a while. And then what happens? Nothing. It just all calms down until there's another killing. You know, the laws aren't, well, we had a little bit of a law changed with the removal of malice, but, you know, are there any other laws that have been altered? Usually not. And then we get to Derek Chauvin's killing of George Floyd. That case brought national attention, actually, as you all know, international attention to the case. And when he eventually got convicted, there was dancing in the streets. Not only that, but there were reform measures passed. In the state of Washington, the governor signed into law in this year 12 new laws reforming how police officers should handle cases. Prohibiting, I'll just give you a sample of them, prohibiting chokeholds, restricting the use of tear gas, requiring officers to intervene when excessive force is being used by a fellow officer. So there are laws that are being changed, but also we're noticing that there have been backlashes since the Floyd case, since George Floyd was killed and Chauvin was convicted. In different states across the United States, there are efforts being made to block any reform measures. And in fact, legislatures showing that they have the officers back are trying to pass more restrictive laws that benefit police officers. So things have been changed, surely, lately, but will we now have that vicious cycle starting over again where there's a calm until there's another killing, and then maybe there's some more change? There's a lot to be done in the area of law enforcement deaths that can be, and Washington gives you a good roadway to solving the problem. I think, you know, if the folks that are interested in reforming the law with regards to police officer deaths should take a good look at the 12 pieces of legislation that were passed in the state of Washington. Okay. We're going to delve into the role of the prosecutor and the prosecutor's history. And it's critically important to the question of how do we go about reforming the criminal justice system. What I'm going to describe as the prosecutor's role and the prosecutor's history is in conflict with the beliefs of most people, I think, and also of some law students, law professors, lawyers, you know, and even some wrong-minded prosecutors out there. Because the media, the movies, television, books, they need a villain. And a prosecutor is a perfect villain wearing a black hat. You know, we even have My Cousin Vinny, you know. So there's a belief that prosecutors, their job is to file charges or not file charges. And if charges are filed, to gain a conviction and then protect that conviction on appeal. That's what a lot of people think. But that's not really the role of the prosecutor. Let's go back in history, because there is value in history, as I think I mentioned before. Our criminal justice system in America began patterned after the English system, which was a private system where you had barristers that were in private practice who would become prosecutors. And so we had private prosecution in America when we started out. And it lasted into the 1900s. Let me give you an example. We're going to go to Boise, Idaho, travel over to Boise, Idaho, and see what took place. This is the former, we're going back a ways here. You know, this is way back at the start of the 1900s, 1905, in fact. This is Frank Stuhnberg. He was the former governor of Idaho. And on Christmas Day, 1905, he was heading home to his very nice house. He was then a banker, and it was just strolling home. The lights were on. This Christmas tree was in the front living room, and you see that fence there. There was a gate there. There's no gate there now. And the ex-governor reached for the gate and went to open it, and there was an explosion because people had planted a bomb on his front gate to kill him. You can see there's the what's remaining of the gate. They arrested soon afterwards Harry Orchard, a good target for arrest. He had several other problems. Harry Orchard, in fact, confessed and said that he was acting on behalf of an organization headed by Big Bill Hayward, who was a union boss. And so the case came to trial for the prosecution of the murder case of the former governor. And here's the defense lawyer. That's Clarence Darrow. You've all heard of Clarence Darrow, of course. Probably the most famous trial lawyer in America during that period of time. And so there's the defense counsel. Well, who are the prosecutors? The elected prosecutor is standing. He's Owen Bendon. Sitting are his assistants. And I point out on the right, the gentleman is named James Hawley. Well, the newspaper came to Hawley and said, "Are you acting here?" Because Hawley was not in the prosecutor's office. He was asked, "Are you acting here on a private interest?" because, why are you doing this? This is a public prosecution. And he basically said, look, I'm not. I'm appointed by the elected prosecutor. And that's appropriate under the statute that exists in the state. Well, Anthony Lucas, by the way, this story comes from a wonderful book called Big Trouble. And Anthony Lucas, the author of this, says, well, that really wasn't true. That, in fact, Hawley was not, there was no statute authorizing what Hawley was doing. And this is what Lucas wrote in Big Trouble. And remember, this is 1905. This is not going back to our early history. He said, quote, the practice of hiring private counsel to assist prosecutors was an old one in the West, where it was rare to find competent prosecuting attorneys at the county level, and where the mixture of public functions and private interest was endemic. And then Lucas, in a footnote, writes, in southern states, when a black man was charged with raping a white woman, it was long the practice for the family of the victim, bent on rage, to provide the prosecutor. So we had private prosecutions lasting until the beginning of the 1900s. It wasn't until 1987 that the United States Supreme Court decided that American prosecutors could not have any private interest in the case, that we have public prosecutors. Well, there are those who would contend we should have a barrister system. The idea of on one day you may be representing the defendant, and then you're picked by the Crown to represent the government and the public. On the other hand, just the way it is in England. So there are other options, but we are a public prosecution system, and that it goes back some time. And 1987, it was declared you could not have a private interest. Here is the key case in the United States. If every state, I think, cites Berger versus the United States as the case that defined the role of America's prosecutor, and it is in stark contrast to the public's perception, much of the public's perception of what a prosecutor's role is. And here it's referring to the United States attorneys, but this case is cited likewise for state and local prosecutors as well. Here's the language. The United States attorney is the representative not of an ordinary party to a controversy, but of a sovereignty whose obligation to govern impartially is as compelling as an obligation to govern at all, and whose interest, therefore, in criminal prosecution is not that it shall win a case, but that justice shall be done. As such, it should be he, she, is in a peculiar and very definite sense the servant of the law, the twofold aim of which is that guilt shall not escape nor innocence suffer. Well, that concept that it's the prosecutor is the servant of the law and is not and represents a sovereignty and is not just there to convict, is now in the model rule of professional conduct that is adopted throughout the United States. That rule provides, and here it is, it's Rule of Professional Conduct 3.8, a responsibility, this is the comment, a prosecutor has the responsibility of a minister of justice and not simply that of an advocate. What's this mean? Well, the concept of a prosecutor as being no more than someone who files charges, thinks only of getting a conviction. Remember, Berger says, no, that's not your job. You're not there just to convict. And then to defend it, no, you're supposed to be a minister of justice. And once prosecutors understand that. They understand their job is to find justice, and that means reforming the criminal justice system if it is not serving justice. So the next topic we're going to take a look at is the Brady Rule, which is just an extension of, and it epitomizes the role of the prosecutor and as a reformer of the criminal justice system. The Brady Rule is basically due process clause imposes upon the prosecution the obligation of providing full discovery to the defense of any exculpatory evidence, material evidence favorable to the defendant, either as to guilt or as to punishment. And then that likewise is in the model rules of professional conduct. And so it's an ethical rule. You know, it's not only a due process rule, it's also an ethical rule, and stated over and over again throughout the law in every state in the United States. Well, what does that mean? Let's take a case example. Ted Stevens, congressman, he had a very nice house, but he had it renovated. He had someone gave him one of these great massage chairs that he had down in his basement. Well, he didn't tell anybody about it. And as a member of Congress, you're required to disclose gratuities that you get. So he failed to disclose it, which is a crime. And he got prosecuted for it. The prosecutor is Brenda Morris, one of the prosecution team. And what happened? Well, Stevens got convicted of failing to disclose the gratuities that he had received. What happened to it, to the conviction? It's dismissed. What was the ethical violation by the prosecutor? The prosecutor violated the Brady Rule. The prosecutor failed to turn over the evidence. After the court dismissed the conviction, there was a 500-page special counsel's report, and it stated the investigation and prosecution of U.S. Senator Ted Stevens were permeated by systematic concealment of significant exculpatory evidence. Think about it for a moment. I mean, the irony of this case, here they're prosecuting a congressman for failing to disclose gratuities that he's received. And what are they doing? They're concealing evidence that they're required under the Brady Rule to turn over. So it's really laughable if it weren't so tragic. How serious was this? Well, during the investigation, Nicholas March committed suicide. One of the prosecutors went to the basement and killed himself as a result of the embarrassment for failing to comply with the Brady Rule. Reform measures. It's key that not only everyone in the office from the top down requires compliance with the Brady Rule. When my mentor in the prosecutor's office, one of them was Dave Berner, and I don't know if he coined the phrase, but it's a good one. He said about it, if the evidence in the case hurts your case, give it up. And if it really hurts, that's all the more reason to give it over to the defense. So the whole idea is turn it over. If you're playing cards as a prosecutor, you put your hand down so the other side can see it. It's mandatory. And the other part of it, and the practical part of it, is you want an open file policy. You turn over everything, police reports, everything to the defense except for, confidential information. The Brady rule doesn't just apply to prosecutors, people in the prosecutor's office. It applies to the whole prosecution team, and that includes the police department. So prosecutors are required to get that information from the police department so they can turn it over to the defense. All right, wrongful convictions, our fourth area. There's this wonderful book, Just Mercy, by Brian Stevens. And he represented a man named Hinton. And let's just take a look at a little brief excerpt from it. After we presented test results that confirmed his innocence in 2000, I begged the prosecutors to retest the evidence. But for 15 years, they refused. The state continued trying to execute Mr. Hinton until he won a ruling in the United States Supreme Court in 2015 that required the prosecutors to finally re-examine the evidence. The evidence confirmed his innocence, and Mr. Hinton became the 152nd person in America exonerated and proved innocent after having been wrongfully convicted and sentenced to death. 152 have been exonerated. But the point here is that what is the prosecutor's role? Who should be involved in innocent projects? Here, as Brian Stevenson has indicated, the prosecutor resisted retesting. Should the prosecutor resist it? What's the role of the prosecutor? Is it to just defend the conviction, or is it to step up and do everything to find the truth in accordance with Berger? So it wasn't, this whole idea of innocence projects is relatively new. The Northwestern Law School created the Center on Wrongful Convictions in 1999. And back then, this is what the attitude was back then. If we're thinking about reforming the system, back then the attitude was wrongful convictions were viewed as anomalies, rare exceptions to an otherwise well-oiled criminal justice machine. That's how they were thought of back then. Well, now, as we saw with the quote from Brian Stevenson's book, there are innocence projects across the United States. The Northwestern one is excellent. I would really recommend their site if you want to delve down into it, because what they do is on the site is they have particular areas of problems that exist that result in wrongful convictions. And then they offer, here are solutions to prevent that problem from happening. So these are very concrete reform measures that can be taken during investigations or during the filing of charges, or even after convictions. Certain steps that can be taken to make sure that things don't go wrong. Let me just give you some examples. On the left-hand side are the problems, and directly across are the reform measures. Witness misidentification. Well, to prevent it, there are several other measures that can be used, but for example, the double-blind procedure. In other words, instead of having the detective who knows that this is the suspect that's in the, if it's a show-up lineup, knows who the suspect is and might somehow influence the person that's being asked whether or not the person's in the lineup. Instead of having that detective that knows the case involved, you have another investigator conduct the procedure. So that investigator has no idea who the suspect is in the lineup. False confessions, investigators can use ruses. They can lie to suspects, but you can limit the types of lies that investigators use. And that's the reform measure. Unreliability in forensic evidence, make sure there's training standards, make sure that that those that are conducting are accredited. So there are many more that the center offers, but these are measures that local law enforcement can use. Prosecutors can lead the way to make sure that they're enforced. I want to give you a personal example of innocence projects, and in the book I've got several, but Deever versus Fowler is one that just sticks with me. There was a fire in Immaculate Conception Church in Seattle, and it started in the basement. There was straw underneath the Christmas tree, and it caught on fire. There was a fireball that resulted in killing one of the parishioners who was at the church as she was going up the stairs from the basement. Denny Fowler, fire inspector, presented a case to the King County Prosecutor's Office, attempting to charge Deever, and this was front page news. So I was chief criminal deputy at the time, and I asked the filing deputy not to file charges. I asked her to write up the certificate of probable cause, which is a document supporting the charging documents called an information, which is called an information. But don't file the case. I want to look at it before we file anything, or we may not file it. Well, that certificate got into the hands of another deputy prosecutor, and the case got filed. After it was filed, defense counsel came to me, and they had statements from witnesses that, in fact, Denny Fowler, they had witnesses that Deever had been in the choir box at the time that the fire started. There was no way he was able to get out of the choir box. This was during the service, and go down into the basement and set the fire. I personally went up and moved to dismiss the case, and it was dismissed. The defense lawyer in the case, a couple fine lawyers, both said that they were gratified that charges had been dismissed because their client was clearly innocent. But on the other hand, he was devastated by what had happened. So he sued. Deever sued. And who got charged? Well, Denny Fowler was alleged as a defendant, and I was also. So I had dismissed the case, but now I'm the defendant in a civil suit. They deposed me for a day and a half. And after that happened, they decided that they'd dismiss me out of the lawsuit, and I became a witness. I testified at trial. My former mentor and the former chief criminal deputy, Dave Berner, testified also as an expert witness. Both of us testifying that the case should not have been filed. It resulted, went up on they came back with a verdict, but it went up on appeal, and it was remanded down for a new trial. Eventually the case settled. But the point of all this is that my job was not to uphold the filing of charges, to make sure that Deever got convicted. My job was to make sure that he was not convicted. And so that's the role of a prosecutor. I've got numerous other examples in the book of efforts by others to make sure that justice is done. Okay, let's take a look at the last one here, which is education and reform. When I started in the prosecutor's office, the way in which you learned how to try a case was the sink or swim method. You would maybe sit as a second chair and put on a couple witnesses and have a more senior lawyer be there as lead counsel. And that would happen maybe a couple times. And then you were turned loose to go to trial and handle it yourself. Well, back then, when I went through law school, there were no trial advocacy courses or pretrial advocacy courses. I knew nothing about trial work when I started in the King County Prosecutor's Office. So I swam, but I really was not trained well at all. Well, I was sitting in my office years later, and I received a call from Bob Fertitta, who was the dean of the National College of District Attorneys, and he offered me a job. By then I'd been with the King County Prosecutor's Office for roughly 27 years, and my kids were up. I was basically, my wife and I were in an empty nest. And Bob offered me this job to go from Seattle to Columbia, South Carolina. And I had worked for the National College of District Attorneys when I was on leave. I took a leave for about 2 years after 10 years in the prosecutor's office and worked for the National College in Houston, Texas. Well, when Bob called me about this, the National College was still housed in Houston. And he told me this story about what had happened. He wanted me to come there and be the senior training counsel. And he said, this is what's happened. He said, there's Senator Fritz Hollings was approached by United States attorneys, and they wanted to have a place where they could train. They wanted something like Quantico, where they could go and be trained. And they were tired of doing it in hotels across the United States and in ballrooms and that sort of thing. And Hollings said, okay, I can get that through Congress. By the way, the center, when it was finally built, is the Hollings Center, National Center. He said, but there are two conditions. First, he said, it will be, because he's from South Carolina, it will be in Columbia, South Carolina. And the second condition is it won't be for just U.S. attorneys. It will be for state and local prosecutors as well. So what Dean Fertitta was calling me about was to be on that half of the building. By the way, it was like 20,000 square feet, and half of the building was devoted to U.S. attorneys being trained there, and the other half was devoted to state and local prosecutors. So Bob sent me, the dean sent me a picture of what it looked like. It was under construction. There was nothing, absolutely nothing before this. And it's right on the University of South Carolina campus. I thought, there won't be another opportunity in my lifetime to do anything like this. It was like being a pioneer, heading outward and just starting from scratch. So I talked to my wife, who'd been kind enough to agree when we went to Houston way back when, and for a couple of years. And I said, I asked the local, my elected prosecutor at the time, I'd like to take a 2-year leave. By the way, I ended up staying 6 instead of just 2 years because I loved it so much. So I took a leave, and we packed up and moved to South Carolina. It's a wonderful facility. It's looked like little Versailles of the South. It's fabulous. It has sleeping quarters. It has 5 courtrooms. Here's the dining room. What was happening was we're bringing in people every single week from all across the United States to be trained. These are state and local prosecutors. Many of the offices could not afford to send their staff or their prosecutors off to a national program, much less one that lasted for a full week. And they were all coming down to stay a full week. They'd be trained from morning till night, and they'd also have an exchange with other prosecutors. It was a wonderful, wonderful arrangement. Here's just we would bring in faculty. This is the faculty for one of the courses. That's me. Let's see, 4 from the right in the back. So we would bring in prosecutors from all across the United States, and we brought the highest quality prosecutors you could find. And their job was to split up. We'd have like three prosecutors per room, courtroom, and they would work with the attendees. And this is one class. And so the faculty's here and the attendees from all across the United States. So it was a wonderful, wonderful program. Well, unfortunately, in 2000, I returned home after 6 years. I went back to Seattle. And the center was still up and going and was going quite strongly. Again, how important is it to train these folks? Most of them will not get the kind of training that they got at the center, ethical or otherwise. They wouldn't learn about the role of the prosecutor's office in the same way that it's taught at was taught at the National Advocacy Center, unless they have a top-notch local program. 95% of all criminal prosecutions in the United States are being done by state and local prosecutors. That building is still there, the National Advocacy Center. It's only being used by those folks that are prosecuting the other 5%. U.S. attorneys are trained there to this day. But unfortunately, in 2007, the lobbying effort on the national level to fund state and local prosecutor training dried up and went away. And as a consequence, they closed the door to state and local prosecutors. And now there is no national training center for state and local prosecutors. Prosecutors can still pay a fee and go to some national training, but it's nothing like what they had. Well, it's a sad story. You have the Reformation, with the creation of a centralized training facility for state and local prosecutors, where they were trained to have a reform mindset, not just get a conviction and protect that conviction, but to make a difference and do justice. It dried up and went away. Well, does it have to be that way? The answer is no. It started with one person. That's all it took. And part of the theme of the book is that one person can make a difference. So that's all I have. Okay. Any questions, thoughts, observations? And by the way, thank you for letting me do this.
Okay.
Are we done?
That was fantastic. And we do have a couple of questions for you. Sorry, apparently I was on mute.
Okay.
First, though, I want to go ahead and remedy a mistake of my own. I neglected to mention our co-host. Morgan Wright is the lead editor of the Full Court Press publication wing of Fastcase, and she is also here to participate in the question and answer session now. So Morgan?
Thanks very much, Erin, and thank you, Ron, for this wonderful talk. So relevant to our country right now. I mean, it always has been, but it's so helpful to have that historical context and, more importantly, the steps we can take for the future to remedy some of these problems. And I should say this is the second book that Ron has published with Full Court Press. He also has a wonderful book with a few of his co-authors on visual litigation strategies in the courtroom, which you can also find on the Fastcase bookstore website if that's of interest to you. With that, Erin, I believe we have a question from the audience.
We do indeed. So this is hearkening back to an earlier statement where you were talking about the responsibility of the prosecutor to divulge information, especially exculpatory information. So the question is regarding the process or means by which the prosecution does so. Specifically, the tendency of some prosecutors to offer mounds or mountains or oceans worth of information with the exculpatory information somewhere in that large stack of information. The question specifically is, does or should the prosecutor have an obligation to identify what exactly is the exculpatory evidence, or leave it to the defense counsel to do this sifting or finding of information in the large stack of information?
I think that's a great question. The answer is you've got to turn it over. I mean, if you're talking about what's the legal obligation, it's you've got to turn it over. I know what you're talking about in terms of turning over stacks of information and then leaving it up to the defense to crawl through it. The question is, are they legally required to? The answer is no. At least in my opinion, it's no. Is it wise to make sure that the information is pinpointed? I think it's a good point, and I think so. I mean, if your job is to make sure justice is done, and it's of significance to the case. Of course, the beauty of being a prosecutor is if it is that significant and it really hurts your case to the extent that you don't have one, the beauty is that you just dismiss it. I've often said that if you're a deputy prosecutor and you're on the filing unit, you'll probably if you have a few months stint on the filing unit, you're going to be not filing cases and sending them back to the police department. You get more getting rid of cases than a defense lawyer will in a lifetime. So of trying cases and trying to negotiate them out. But no, so if the question is if it's really significant, if it is really significant, you ought to take another look at your case and maybe dismiss it. But does that answer your question? Any follow-up on that?
I think that does answer the question, but we have additional questions as well. Morgan?
Sure. So I had a question for you myself. In your closing remarks, you said it really takes one person to make a difference. And it seems to me that a lot of these problems are really cultural problems within the prosecution offices. What are the key takeaways of actionable items you think people can take from your book? What are the first steps to really change the culture of the office and to, act in the pursuit of justice rather than maybe the pursuit of ego?
Well, first and foremost, I just want to underline the idea of a small group of people making the difference. And I think it's, the leadership role in saying, having a reform mindset. I've only given you maybe a couple examples, but, the one with the Advocacy Center primarily. But when I started out, the office in King County, the prosecutor had been there for over 20 years. And he used the office in a political way. Chris Bailey came in beat that prosecutor in an election and came in and made it non-political. And so one of the takeaways is that the prosecutor's office should be non-political. And I think that's a key. It's the corruption, in fact, came about through politics. And so takeaway is that a small group of prosecutors, we had police corruption going back to territorial days in Seattle. And it went on forever. People ask me, do you have organized crime in Seattle? I said, we had one of the largest organized crime groups in Seattle, the Seattle Police Department. The graft went all the way up the line. So it took just a very small, half a dozen folks to prosecute those cases. So I think the takeaway is you can have a small group and you can make a major difference. Another takeaway is don't just think about your job as working on cases. It also involves legislation, working on legislation, writing it, lobbying for it, and going public. So that's just a couple thoughts on it.
Thanks. I mean, we only have a few minutes left, so if you have a question, please type that in the question box now. But I did want to remind everyone that Aaron has posted a link in the chat that goes directly to the Fastcase bookstore if you're interested in purchasing the ebook. That's a downloadable ebook. If you're interested in a print version of the book, that's only available on Amazon. You should be able to find it relatively quickly by searching the title and Mr. Clark's name. He has self-published the print book, so that's where you can find the print copy. And as I mentioned again, also on the Fastcase store, we have Mr. Clark's other book, which is called Visual Litigation. So, Aaron, is there any other closing remarks you'd like to make while we wait to see if there are more questions?
Yes, we do have a couple of closing thoughts. First off, I'd like to thank Mr. Clark for joining us for today's session. It was truly excellent, and also commend you to everybody the books, as Morgan just mentioned. I'd also like to remind everyone that we will be sending a copy of today's recording, a link to it, to everybody who registered for the webinar. Do have patience, it usually goes out the next day. We will also be having further author webinars in the future. So I really encourage you to keep an eye out for that announcement as we go. We have some excellent authors coming up, so please stay tuned for the future sessions. And I also wanted to go ahead and share a comment that just came in from the audience, which is that the phrase "to do justice" is written directly into the Texas Code of Criminal Procedure, but it is all too often ignored and pushed to the side during negotiations. I think that's quite an astute observation, and one that fits well with the theme of today's webinar. So I don't think we have any additional questions, but Ron, do you have any closing thoughts you'd like to share with everyone?
I just want to express my thanks to you, Aaron, and also to Morgan. It's been a joy to work with Full Court Press and Fastcase. And I want to thank everybody. I hope that if I can possibly, one of the things I really hope to do with the book was to inspire folks to get out there and make changes. It's an ongoing process. Basically, the book is a little history lesson, and hopefully will offer you some inspiration that things can be done, and also give some concrete, very practical advice on how to go about doing it. And thank you to everyone. Thank you.
Thank you. As Aaron mentioned, you can watch the recording of this on our YouTube channel along with all of our other author webinars. Just search Fastcase on YouTube, should come right up. And we want to thank you all for attending. And again, thanks to Mr. Clark for his time and giving this wonderfully prepared presentation. So long.
Thank you,
Bye-bye.
everyone. Great afternoon.